Welcome, everyone, to this Professional Development Hour presentation brought to you proudly by the Atlanta Metro chapter of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. Before we begin, we'd like to let you know that any opinions presented tonight are solely the opinions of the presenter and not that of the Georgia Society of Professional Engineers, the National Society of Professional Engineers, or any other of its affiliates. We certainly hope you will enjoy tonight's presentation, so sit back and relax, and on with the show.
Okay, go ahead.
Well, good evening, folks. Tonight's program is on the subject of PE and PLS stamp and document fraud. There are occasions when documents prepared for people get misused. There's also occasions when people without credentials are attempting to authenticate certain information. This situation can be deadly and it can be expensive. One of the people who often joins us, he was involved in a South American fraud attempt that was an $11 billion judgment against an American oil company. Yeah, that was a criminal enterprise. So tonight's speakers, I'll let them introduce themselves.
All right.
I'm Bill Woolman. I am a retired consulting engineer and an ex-board member on the Georgia Professional Engineers Land Surveyors Board.
I'm Daniel Smith. I'm Assistant Attorney General at the Office of the Attorney General's Office of Georgia, and I serve as counsel for the Professional Engineering Land Surveyors Board as their assigned counsel.
Good evening. My name is Ross Bunshoe. I'm a Vice President, Client Executive at Grayling Insurance Brokerage. We're a specialty brokerage that focuses on all property casualty insurance for architects and engineers.
Are you ready? Okay. We can envision several variations on such document stamps and stamp frauds. Materially changing a document after it's been stamped, sealed, copying the stamp and signature from one drawing to another, using another person's stamp, that's a big no-no, using a bogus stamp, just making one up and hoping somebody will not notice. And what about AI and other things? Is there other variations that come to mind?
Probably the biggest one I'll start is right now the industry is having a problem with AI-generated documents, which will also generate a stamp on that document. So you can buy something on the internet that you have no clue if it's right or wrong, but you think it's right when you buy it. So that's a problem. And yes, the stealing of stamps has been around for a very, very long time. And making up stamps, and that's another thing that AI has been known to do, is make up a stamp, make up a number, make up a name, make up a business name, and therefore the jurisdiction has no way of knowing where it came from.
I don't know that I can think of something that's totally novel from the items listed there. I would say from the enforcement side, a common problem that we see is in a firm where there's not perhaps the best practices for keeping your stamp kind of exclusive and an audit trail, those type of things. You end up with these circumstances where you have this malformed plat that is stamped by somebody, and you can't ever figure out who actually did the stamping. So so-and-so will say, well, so-and-so, that person talked to that person, will say, well, that person did it. And ultimately we'll get to the top of the chain, it'll be the proprietor or whoever actually owns the stamp there, and they will disclaim any knowledge of its usage there. So it's very difficult to pin down how it's been misused up to that point there.
I think probably one of the most common circumstances we see from a liability perspective is when a contractor or developer through contract, obtains ownership of the instruments of service, and then takes those drawings or the design and moves it to another location and hires a new designer to take that prior design and modify it to fit the site. And when a claim arises, there's always a little bit of a dispute as to who is responsible for what aspect of the design. Is it the prior designer who originally created the design, or is it the subsequent designer who fit it to the site?
Does anybody have an example of that you're aware of such frauds?
Okay. Hi, everybody. So it didn't happen to me, but it happened to a colleague when I did ask around. And the way he told me was he was working one day, and then he got a phone call from a government entity, we'll say. And they're like, hey, did you work on these plans for this project? And he went, I've never heard this project before. And so when they investigated, they found out that a construction company, who's not even based in the United States, had just made a seal, put it on the plans, it's not even his signature, and then sent it off. And so luckily, the company that we work for helped out and resolve that. But then, so I'm not normally from Georgia. And so my first question was, well, isn't it electronic? Because he said it was like 2 years ago. And I was like, isn't it not electronic? And he's like, no, it's just a little picture. And I was like, so that's the story I have that where someone's like taking it. And I was like, ooh, as new PE, ooh.
Back when I was doing this stuff and creating drawings, and it's been a few years, where I got the material, people didn't much care about, but when it was finished and I signed it and I stamped it, I took responsibility for everything on the drawing. There was no question that I could say, well, that part there, I just got from somebody else and I'm not responsible for it. I mean, that would never fly. If I signed the drawing, I've owned it all, whether I created it or not. So when I heard that question about whether the former designer or the present, I think the last one that touches it wins.
All right, I'll give you one that actually happened to me probably 45 years ago. That is, I did a strip shopping center in North Georgia for a developer. About 3 years later, I get a call from another AHJ, authority having jurisdiction, saying my drawings were wrong. And I said, what drawings? As it turns out, the developer took a set of documents, cut the name of the shopping center and address out, glued in a new one 3 years later, printed it and turned it in. And the only way he got caught was I went through a code cycle. The original drawings were correct, the new drawings had an error in it, and I got called. That's how it can be stolen very easily. But right now, with the advent of electronic sealing, you can lift a stamp and a signature and a date off of any drawing in any permit office that's online. That's a problem. I know that NCES is starting to work on this, and I don't know the last meeting I went to at the enforcement forum, the last question that was raised was, and y'all think about this, is there a better way to certify a document than a stamp and a signature?
And Bill, I will add, yes, there absolutely is. The technology has been around for decades. This is nothing new. Electronic signatures, proper electronic signatures, are one-way math equations that if you so much as change one bit in that drawing, the signature will fail. It's unfortunate that for whatever reason, the various powers that be fail to utilize this age-old technology.
Let me give you a little rebuttal to that. when I was on the board, this has been an ongoing thing. I left the board in October of last year. Probably 4 or 5 years we've talked about it, and one of the problems is the cost to the registrant to do that. Now,
Free.
free?
Free. $0.
Then I need to
Download a piece of software.
I need to talk to you after this meeting, because most of the, quote, people who do this, like if you're licensed in Florida, Florida requires you to do one of like 3 different firms. It's $300 a year annually to do that, and it is protected. But the Georgia board, at my time there, we did not want to add that to 25,000 registrants in the state of Georgia.
Yeah, and that, I think, is really the problem, is these oftentimes government entities get roped in for whatever reason. It's lack of knowledge. It's getting swayed by the fancy sales guy that comes in, or whatever the reasons happen to be. Yeah, sure, there's people out there that will charge you lots of money for what is otherwise free, and that's unfortunate.
Now, that would address the drawing that had been submitted electronically and had been altered between it was stamped and when it was submitted. But if somebody creates a whole new fictional drawing, it does not address that.
It does, because they will know that it was not the person who they claim to be. Because of that one-way math function, you only, so if I sign the document and you're trying to reproduce and put my name on it, your signature, it may say Steve Strong on it, but it will not match my signature. And the other side of that key, it's an asymmetric key. The public key is freely available. So if you run that public key against the document that has my private key on it, or a fictitious private key, it will fail the signature check.
That requires the agency having jurisdiction to filter for those.
Yeah, but it's easy. Again, it's publicly available information. The point of a public key is it's just that, it's public. And there's also things that are called fingerprints that you can use, so that if somebody says, here's my public key, but then what I do, for example, is in every email and on your LinkedIn profile, wherever you want to put it, you put your public key fingerprint. So that is a way of confirming, so that if somebody tries to say, oh, here's the public key for Steve Strong, you'll see my fingerprint, when you check the fingerprint on that public key, doesn't match, so you know it's a fraudulent public key.
Just to jump there, because you speak my language here, and I'm delighted to speak perhaps obliquely, that the board is taking proactive measures for exactly what you're talking about there. But the asymmetric key, the public aspect of it, so you can identify who has actually signed this with their private key. I feel like that is such a great trend for the electronic world, because, like you said, you can't tamper with one bit without throwing off the math. That the technology has been around. I mean, PGP, I think, was like 1994, somewhere around there. It's all just been so much better since then. So my hope is that as things kind of progress forward, naturally the electronic usurpation of kind of hard copies will lead to some progress on that front there.
Would there be an incentive for insurance companies, for companies that are using such technology?
Probably yes. That is a very lawyerly answer, and I apologize for that. Stamp fraud, it really hasn't moved the needle. It's not a trend that's on the radar of insurance programs right now. Professional liability, which is our biggest spend here as architects and engineers, generally does not cover these types of services or these particular types of claims, because it's not a specific liability, right? It is a first party coverage, which means that it is damage to you, therefore a first party coverage will cover the loss that you incur, whereas third party or liability, such as professional liability, will cover the costs for a third party who is suing you or has a claim against you. So with that said, the way to actually cover something like this or any kind of stamp fraud, there are 2 additional coverages that would arguably cover these types of claims. One of them is pretty on the nose, is crime coverage. Crime coverage covers forgery or any kind of crime that might be perpetrated on the insured. So the engineering firm would be covered for any kind of crime that might have been perpetrated. And those crimes are, for the most part, limited to anything that causes economic loss. That's coverage number one. Coverage number two would be arguably your cyber coverage would also cover something from this loss. If the bad actor got into the engineer's system and recovered the stamp that way, then that would trigger your cyber coverage as well.
I've heard other states have said that about 10% of the complaints to the licensing boards involve fraud of various sorts, document fraud. Do you have experience in this state, and what's the trend?
Okay. I don't know that I can pin it down to a specific ratio or percentage. I would say that the most substantively kind of juiciest claims, so to speak, are the ones that involve fraud. And like we kind of referenced earlier, there's just a whole range of that. It could be something where there's a licensee whose stamp has been misused. It could be something where someone is just cutting and stealing someone's stamp there. So there's a good range of it there. I would say that they're certainly the most impactful of the ones that we see on the enforcement side.
How is the fraud typically detected?
It is often, I don't know if I can speak to typical, but I can say that of the ones I've observed, it typically comes from, as I said, typical, and I can't say typically, but the ones that I've seen come from someone noticing it and reporting it. So there's this public aspect of it that I think is understated, where kind of self-policing among licensees to say, hey, that doesn't look right. Let me go tell the board about that, and that kind of launches an investigation. Our board members are so thorough and go so far above and beyond just looking at the surface to go through years to see if there's a pattern, to see if there are other things that didn't go reported. So there really is a public aspect to it that I think is quite important to identifying that.
The most important detectors would be the agency having jurisdiction?
Certainly.
And typically, that's correct, but that means that there's 159 counties in Georgia, plus municipalities, et cetera. You've got to get them on board, and they are not on board. But that they are the first line of defense. That when somebody submits a pile of garbage, they don't give them a permit. But it's not happening that often. Usually, and Daniel's right, it comes from somebody else who sees the drawings and says this is garbage, and they contact the board.
I believe, Bill, you had related that land surveyors are more eager to report.
I was corrected on this. We used to have a saying in the board that surveyors eat surveyors, but engineers don't eat engineers. And I never did figure that one out until one of the surveyors on the board explained it to me. And that is, if you're doing an engineering project, you do the project, 2 years later somebody else either modifies it or adds to it, they work around whatever they see. If you're a surveyor, hold that please. If you're a surveyor, you have a line. If you're the next surveyor, you hit the line. If you don't hit that line, there's a problem between one of the two of you. That's why surveying is much more difficult, or it's easier to report somebody not doing their job, simply because there is a definite line that has to be done. Does that make sense to you?
Is there any legal requirement for someone who discovers such a fraud to report it, and report it to who?
Yes. It's actually in the law, 4315, that you are to report it to the board and assist the board in getting information.
Everything he said.
A little bit different angle. Report it to your insurance carriers, particularly if you have a crime policy or a cyber policy. Be sure to report it there. And you can report it to your professional liability carrier as well, who might be able to help you with the process on a consultative advice.
How do licensed engineers need to protect themselves in cases where they are not actively practicing but maintaining their license, and or working for an employer who's taking the responsibility and liability for the designs that are being stamped? In the case where you can just go on a state website and look up a name and a license registration number and create a fake stamp and seal drawings on, if that were to happen. So what is the risk and the liability to the individual affected licensed engineer, and what do they need to do to protect themselves?
So generally, the prior employer and their professional liability would cover any prior work while that employee was employed there. So that professional liability insurance should carry over and provide that protection for any prior work during that employment. However, I think your question is that new fraudulent design work is being performed by this retired engineer by a bad actor. Is that right? So a bad actor is performing this work with the stamp of a retired employee.
Use someone else's stamp.
Yeah. In that particular case, when you find out about it, because you guys know more about this when you find out about it, I mean, you need to report it to the board immediately.
Really, to answer your question, same problem I have. Somebody steals my stamp, I'm not going to know it unless there's a problem with the design. But my stamp is locked in a file drawer in my basement. I know who uses it. That's really, it's up to the engineer while he's working to protect his stamp, his or her stamp. That's part of the law. You are, as the gentleman over here said, you're 100% responsible for whatever you stamp. Little Johnny in your office didn't make the mistake if you stamped it. You made the mistake. So, you have some responsibility while you're working. When you stop, I have probably got 4,000 or 5,000 projects that are stamped out there in my career. Somebody can take my stamp. It has the same number since I started, doing this. There really is no way to protect yourself. Truthfully, it's the authorities having jurisdiction who's got to help us. By that, when some pile of garbage goes in, they've got to question it, not just turn a blind eye.
Is there any requirement for those authorities, if they suspect something, to report it, other than question the supposed engineer?
So when you say authorities, you mean like the record there?
Yes.
Okay, so yeah, the clerk. So when they look like the Plat Act, right, the responsibility of the final clerk is expressly just to pass along. They are not armed enforcement. They don't have any liability. They're there to kind of a surface level, but they are not. They're like a deep dive into like the board, and that creates an odd tension where that there are people who are filing these bad plats there. And I'm sorry, I didn't want to. There's a tension there where we need to work with these kind of authorities, you could say there, without imposing upon them new responsibilities that don't have a basis in law.
But that's only for surveying. When it comes to plans that are put into building authorities, they get separated out into different disciplines. That has nothing to do with the Plat Act.
Right.
The Plat Act is fairly clear.
Right. There's conforming standards. I just want to make sure that we understand that, like, when we start talking outside of the jurisdiction of the board itself, we can't necessarily invent responsibilities for other places.
There's no existing law requiring them to report.
Talk to your legislator.
Roger.
So I'm just kind of curious because, I'm sure people have bounced around different jobs in their lifetime. So let's just say, I quit that place and then a few years later, someone, have a grudge against me or whatever, and they illegally use my stamp, but I don't work there anymore. Yeah, like screenshot or something in there, put it in there, and then they use it for this development or whatever, and then it's wrong, it doesn't meet code or whatever, and they come back after me because my name's on it, but I don't work there anymore. How are we going to prove my innocence?
Simple. Where's your date of unemployment, if you will? What's your separation notice? If something happens after you leave a firm, you're not responsible for that if they change something after you leave. Now, if you did a design, you quit, you go somewhere else, and then 2 years later they start to build it and there's a mistake in it, yes, you are liable for that. Is that correct?
So the company that you worked for when you performed that design would be liable, because the work that you performed during your employment is the property of that company. So that company would be on the hook and would be liable for any projects that you perform design services for at that time. So for example, if you go ahead and do your design and then you leave that company and a claim arises after you've left the company, that company is still going to be responsible for your design because that design is the property of that existing company.
Okay, so that's one thing, but if say they did it because they want to do some ill intent and say, oh, let's just screw this person over, and then they just malicious intent do it. That's going to be another problem.
Sure, two things. Number one, that is fraud. So you would need to report that to the AHJ. Right.
But it's going to take like years to investigate it, and could be like my name will be screwed for a long time. I guess I just don't want to be put in that situation.
Sure, promptly reporting and aiding in the investigation is the remedy that we have available to us.
From my memory of what I've read previous versions of the state law, it had a clause in there that when the board requested, local law enforcement must cooperate. But I was just the other night reading, it's 25-2-14. Except as provided by code, blah, blah, blah. Yes. Anyways, it's a requirement here that certain things have to be approved prior to construction. And so it's kind of, there's Attorney General or his designated assistant shall act as legal advisor, except as provided by code to all. It shall be the duty of all public officials charged with responsibility of enforcing codes related to construction to require compliance with the code section before engineering plans, drawing specifications are approved for construction. So does that require those boards to do? Yeah.
Sorry. I think in terms of, can you rephrase?
Is that a clause in there that's buried in the law that is affecting agencies holding jurisdiction?
In terms of cooperating with the law enforcement, which part are we referring to here?
In the rectangle.
So, so I see the provision. I guess I'm still. I see it as a statement. I don't know what the question is. I guess it's the question.
Well, then comment it as a statement.
We should work closely with the provisions of law to, if any other authority there, including local law enforcement or anything, whether that's referring to the solicitor, referring to the prosecutor, anything like that.
Next question is how do you involve, or what involvement can you get out of county prosecutors?
Let me throw this out in slight ignorance. The board right now has an investigator. They do not have a chief investigator. When they hire a chief investigator, he will be deputized and he will carry and he will have arrest powers. So if there's something going on now, the board's investigator would have to call and get support from the local authorities if he needed to arrest someone, which quite honestly is not something you see very often. Okay? But once they do hire a chief investigator, he will be a deputized law enforcement person.
I've never seen arrest powers exercised by the board, so this is novel to me.
When I was doing this stuff, I had copies of my drawings. And if somebody takes one and alters it and uses my stamp, once someone else says, we got a problem here, my defense, I suppose, would be my legacy copies that show what they looked like in 1993 or whatever it was. Because the stamp might be the same and the name and all that, but that drawing has changed, and I've got a copy that shows what it used to be.
But that's exactly correct, and that meets the intent of the law, is that you maintain the copy, you maintain the original documents.
Oh, I can't do that. Because Marta owned the originals. I got to make as many 11 by 17 copies as I wanted.
But still, Marta has that original somewhere.
Yeah, I'm
So
sure
that is your defense, if you will.
Yes. I mean, I'm sure they didn't lose it or anything.
This is a outlandish question, but if we were to skip like digital signatures, with the prevalence of AI being a thing in our world now, do you think, or would you see a future where, because human eyes can only do so much and the overload could probably take, when you stare at things too long, you go a little cross-eyed, do you think that AI could help with, if you put your signature and your seal in a database, would AI be able to scan when you submit your plans, go and flag, oh, this one doesn't match what's in the database, nor does a signature match what's in the database, please review this, or is that a touchy subject?
I'm going to answer that one very simply. Do you sign your name exactly the same way every day?
No.
There you go. So AI could not do that for you.
But there is little bits of where, correct, similarities where my T is signed a specific.
It comes down to if AI can do what a professional handwriting expert could do. And I guess you're saying they can't. It can't.
Answer that question.
So I have a question. If you have a company that's producing drawings and they're not based in the U.S. and they're doing work in the U.S. and the work is not being supervised by a licensed structural engineer from the U.S., but someone in the U.S. is sealing them, how does the board get word of this or wind of this, and how do they know when it's happening so that they can put a stop to it?
In terms of how that fact pattern was different from other ones, unfortunately, much of it comes down to what are you aware of as you encounter it. The board can't proactively monitor every kind of document that gets kind of circulated within the industry there. So it really is going to come down to a combination of proactive kind of reporting by licensees as well as the other actors within that, whether it's the kind of commercial stakeholders or the board themselves noticing it. There's not, I just hate to be bearer of bad news. There's just not really a great answer to proactively monitor everything that's out there to see if it's fraudulently in use.
So, to my knowledge, and Phil, correct me if I'm wrong, I believe that the work that's being done should be done under the supervision of a licensed registered engineer, and he should be present when it's going on, and he should be in control of the work, since he's taking responsibility.
The real answer is yes, but remember that when you stamp something, i.e., if your designer does this, you're not watching over your designer every minute of every day
Right.
So your job as the engineer to take total responsibility. You have to check it thoroughly. You have to check calculations. You have to check everything, and you can do it. And probably, as everybody out here knows, they are companies that have canned plans that they then send out and get them, quote, site adapted and stamped. I didn't draw that drawing, but yes, I've had to check every line on it. I've had to check the calculations. I've had to make sure everything is correct before I stamp it, if I were to stamp that. The direct supervision right now has been changed in the law and in the board rule that came out, 2 years ago, a year and a half ago? So go on and look at board rule, I think it's 18012, on stamping of documents and direct supervision, where, the board is totally aware that we don't have that pyramid anymore. The senior engineer, the junior engineers, the designers, and the drafters all sitting in the same office. Your stamping engineer could be in California and you could be doing design in Georgia. And so the way I believe the board put this together, and I worked on that, was if we think that you are not supervising the work, we may ask you for information to prove that you did, i.e., show me emails where you sent red lines back and forth. Show me emails where they did what you asked and went back and forth. Don't just say because Junior did it is not going to work. We're going to require that, or the board will require that, and then you will, you could say, yes, I've done the direct supervision, because you have, and you've done the calculations, you've checked it, you've done all that. But if you just say, well, came from California and I stamped it, that's called plan stamping. Yeah. That will get you in trouble every time. Then you get to see this gentleman.
Just to kind of add on to everything that was said there, and I want to circle back to the question that you raised earlier about kind of using AI detection there. I really think that the march to digital kind of verification is going to provide a lot more mechanisms to address some of these questions there. Because as you talked about there, when you have a procedure that requires a mathematical component of proved identity, it's much more difficult to say, someone, I made these problems there, these problems with my kind of previous things, previous plans, previous plots, whatever it is, and somewhere down the chain that went undetected there. That kind of chain of custody, who signed what, who did it when, that is all something that comes out of the box with this move towards digitization that I think is going to do a lot to curb some of this bad behavior.
Well, one thing I wanted to mention is, like this gentleman up here, I took copies on this drawing that I seal, and I keep copies because you never know when something might come back, and you want to make sure that something wasn't changed while it was, basically under your, supervision, and then, you get blamed for something that someone else maybe modified that you had no knowledge of.
Let me correct one thing. The rule is 180-6.03, number 6. That's the direct supervisory. That has been changed about a year ago.
So it's no longer it is in there. Okay.
I just wanted to emphasize your point. Keep your record drawings, because it could be, the general statute of repose in most of the United States is 10 years. So that means that somebody's got 10 years from the day that the services were performed to file a lawsuit. So keep those drawings, because those are your best defense. The one thing I learned as a young lawyer growing up and representing architects and engineers was, if it is not in writing, then it did not happen.
That's quite interesting. There was one time when I worked for a company and they had gotten sued over something or other. And they announced that they have a new policy that all emails are to be deleted after 90 days. And that was corporate policy. So whether you wanted to or not, they were going to go there and they were going to wipe them after 90 days.
That's concerning.
Well, yeah, but we're talking about drawings. You're not going to delete those every 90 days. But if it's 10 years, I haven't done hit a lick at a snake in 10 years, so I'm okay.
We've been talking about
somebody misusing our stamps while we're walking around kicking and breathing? I know, Bill, that somebody questioned you. What should she do with her deceased husband's 23 different stamps?
Destroy them. You know, I mean, again, logic doesn't come into play, but if something were to arise, if you're dead, you're dead. Certificate of death, you know, will tell you you didn't do that drawing 4 years after you died. You know, but you do have to go to court, and you do have to carry your drawings into the judge and say, this is my original drawing. If you have a set that has one line different, it's not my drawing anymore.
Well, that sounds like defense, but how about prosecuting the perpetrator?
All right, with NCES going to their law enforcement forum, some of the bad actors happen to be in India, Pakistan, a few other places. There's probably no state that will go out internationally for plan stamping.
To your question about how do you go after, you know, the person there, it really depends on who it is, right? If there's this jurisdictional kind of net we need you in to be able to bring enforcement actions of any substance. The reality is that if you are not a licensee, if you're not within state borders there, it's very, very difficult to do something outside of that kind of net there.
Isn't there always a local representative? Isn't there always someone somebody bought that thing from India or Pakistan and submitted it here? Isn't that the person you go after? And it's their problem who they paid to do the actual work.
So when you say you go after, there's who is doing the going after is super important because of the jurisdictional boundaries. So the board can reach this far. The state government can reach this far. Federal prosecutors can reach this far. Is it civil? Is it kind of a criminal matter? These sounds like we're just papering it over with legalese, but these boundaries, the kind of tension between the jurisdictional boundaries, very, very important and very limiting in some respects to how far you can go. So in terms of like the board's authority, really cannot do much more than send a sternly worded cease and desist to, you know, those types of actors there.
On the civil side, which is the other side of the coin from the prosecutorial side, if you are going to go after them, the remedy is money. And even if you do find the bad actor who was forging seals, you kind of got to analyze, you know, they probably don't have any insurance, so there's no money to recover there. What are their assets? Is there a way to recover anything there? And usually in that particular situation, from a civil perspective, the juice just isn't worth the squeeze.
Would you describe utterance?
We need context, please.
Well, the utterance of an officially submitted document.
No. I don't know what the context is.
So I was talking with somebody involved in California, and he was putting forward that if you are submitting a plan that you are claiming was legitimately sealed, that is an utterance, and if you're doing it falsely, that is a crime.
It's like a false utterance in the context as far as a colorable action against someone who's made like a false utterance. Under Title 16, the Georgia Code, there are several provisions for what is essentially analogous to kind of the false utterance there. There's whether it falls under kind of identity theft or identity fraud, that's kind of different. I think there's closer to, I think, a false sworn statement. But there are certainly provisions within, again, Title 16 is that, it's all kind of criminal provisions there. You spent more time on the civil side. I'm unaware of much teeth on the civil side for that. I don't know if you can speak to it.
Yeah, there's really not a lot of teeth. I mean, there aren't really any civil remedies that are specifically codified or you know, torts that could be used. I mean, in my mind, the closest you could get might be a defamation, where you're, you know, or a slander action, but that's as close to an on-the-nose civil cause of action that you could get to.
But my esteemed gentlemen here are correct. If a contractor, let's say, buys a design from Pakistan, builds it, and say it's a bridge and a bridge collapses, you can't find the engineer. Who do you go after? The GC, the contractor, and it's a money issue. It goes back to a civil. What do you sue him for? How much do you get him for that? You're not going to get the designer because the designer doesn't exist.
Yeah, that's right. And from a civil perspective, from that contractor, developer, or owner who purchased the design, it's going to be a fact-intensive inquiry as to what that person knew at the time that they were purchasing the design. Are they what's called a bona fide purchaser, where a reasonable person would think that they are working with a licensed engineer and they're going to get an adequate design for the project that they're performing. If that's the case, then chances are they're not going to be liable. If they're trying to do something or get something on the cheap, they might have been required, or some red flags might have arisen where they probably should have done a little bit more due diligence on the engineer who was performing the design, and then that due diligence would have led them to your website, and that might be and they reach out to you directly from the website, then maybe there's a cause of action there to recover civilly or recover some money from that contractor, developer, owner. But generally, if they are being reasonable in their due diligence in acquiring an engineer, then there's probably not a civil remedy there that's available.
There are about 4 or 5 sites out there right now, websites that you can go buy designs. They're there. Now, why do you do that? To save money. So the answer is, if you buy it, you're probably knowing that you're getting a pile of garbage. But, you've saved yourself $5,000. Now, is that worth, in your mind, is that worth it? It's not worth it to me, but, I'm not the guy making that decision. And we can't legally shut those websites down either.
Right. If I'm an owner or developer or contractor looking for a design and that scope of work doesn't include contract administration or CA, or you're telling me you're not going to visit the site either for the preliminary design phase or for CA, then that should be a red flag. All of us here probably are aware of that. This is not the audience to say that to, but I think that's definitely something that any upstream client of an engineer should be aware of.
What can professional practitioners do to foster a better culture of integrity around document authentication, especially among young professionals in the high-pressure project environments?
As the old engineer, you have to train the young ones. You have to make them understand that this is you. I've always said it, as an engineer, as a consulting engineer, you do not sell a product. You sell a service. The only thing that service has is your name on it. Are you willing to give your name away doing something stupid? I'm not. I haven't in 50-something years. So, therefore, how do you do this in the younger generation? You explain to them, this is your livelihood. This is your life. Are you willing to throw it away for $300? It's up to us to help.
One thing that I've noticed with the younger generation, I would like to think that I'm still a part of the younger generation. I don't know if that's factual or not. The hair's starting to fly south. So, but the thing that I've learned that's effective is trying to convince the younger generation that are you looking at your occupation as a job, or are you looking at your occupation as a career? If it's a job, it's a 9-to-5. You put in the minimal effort. You get your paycheck, and it's purely transactional. As a career, you're invested in the people with you, you're invested in your own craft, and you want to see not only yourself, but those around you and your company continue to thrive. And so trying to implement that paradigm into the younger generation, I think, is paramount here. And I would like to say that I've had success in convincing them, but I think it's still a work in progress.
For each of you, what would you like to see policy or procedural changes in the next few years to help with this issue? Anything?
Education. We need to educate the public, educate the people we work with. We need to have them understand that this is a very good profession. And a few bad apples, as they say, one bad apple can ruin the bushel. We've got to help get rid of the bad one. And we've got to do our job.
AHA?
Well, that's part of it. You know, the board probably needs to do more outreach. And I've said that to them a lot. So hopefully that will come about as they move forward, to educate the AHJs, to educate the public on what we do, how we do it, and kind of why we do it. You know, it's not a game. It's our career and it's our profession.
I mean, I would echo everything you've said there. I think so much of what we've been talking about comes back to an earnest identity with what you do. That, like, ultimately your name is what kind of carries you on this. Whether we can put all the digital things in place, we can put all the enforcement actions in place. At the end of the day, it needs to feel like something you are personally responsible for. You're responsible for your profession, for you, and to kind of uphold that. And that, to your point, the board needs to be involved in fostering that kind of environment. And I think these types of events are so important to kind of build that shared sense of responsibility for kind of preventing fraud.
I think you guys hit all the high notes there. I mean, I agree. I think it's awareness and raising this awareness among owners, contract, just from the civil side, and preventing claims that might include claims of fraud is creating this awareness that there are fraudsters. I think this should be a bit of a conversation with that could be going in tandem with invoices and the deep fakes, where hackers or bad actors are getting involved, getting in between invoicing and then taking an invoice and running away with it. And I think just making awareness and understanding those risks associated with, why is one particular engineer a third of the price as every other quote that you've received or every other proposal that you've received. There need to be issues that raise red flags, and there might be a little bit of extra due diligence on the upstream client side.
Any
other questions, folks?
Topic.
Questions? Well, if there are no more questions, please join me in giving the panel a round of applause. And we have a couple of gifts here for you for taking time from your busy schedule to enlighten us. For the rest of the group, please don't go anywhere. Make sure you sign in your sheet. We've got the door prizes coming up.
Has everybody signed in? You got your name on the list?
Thank you.
We hope you enjoyed this presentation given at one of the Atlanta Metro Chapter meetings of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. To find out more about us or to join us, check us out at GSPE.org.